The big story coming in at this hour is from the Supreme Court. G.N. Saibaba, the former Delhi University professor who was serving a life term for Maoist links, will continue to remain in jail as per the Supreme Court, which has today stayed the Bombay High Court acquittal order. Let me go immediately to Arvind for more details on this. Arvind, take us through what the order says.
In a special Saturday hearing, the Supreme Court has suspended the Bombay High Court judgment wherein the Bombay High Court had discharged former Delhi University Professor Saibaba and 5 others in a case of alleged Maoist links. So this particular case was registered sometime way back in 2014 and Saibaba is currently in jail for last 7.5 years. So the Bombay High Court, in an appeal that was preferred by Saibaba and others challenging the trial court conviction in the case of alleged Maoist links, had discharged all the accused, saying that the sanction under the UAPA, that is the Unlawful Activities Prevention Act, was bad in law, and on that particular technical ground the Bombay High Court had discharged Saibaba and 5 other accused in this particular case. Minutes after the Bombay High Court gave this judgment, Maharashtra government moved the Supreme Court swiftly with an appeal challenging the Bombay High Court order, and the Maharashtra government approached the Supreme Court for an urgent hearing, saying that the accused are expected to be released from the jail based on the Bombay High Court order. So agreeing with the request of the Bombay High Court, Supreme Court on Saturday convened this particular special hearing wherein Solicitor General Tushar Mehta appeared for Maharashtra government and Senior Advocate Basant appeared for Saibaba in this particular case. Solicitor General Tushar Mehta argued before the court, saying that the acquittal order has not been given based on merits but purely on this technical ground, saying that the sanction that was granted to Saibaba and others in this case of Unlawful Activities Prevention Act is improper and bad in law. That cannot be a ground for discharging or acquitting the accused in this particular case. And he also drew the parallel, saying that this is a very serious offence, and he also said that Saibaba was the mastermind in this entire case and that should be taken cognizance, and the Bombay High Court could not have gone into this technical ground and could not have acquitted all these persons. But whereas Senior Advocate Basant appearing for Saibaba, he brought to the court's attention, saying that the sanction under UAPA was granted to Saibaba, against Saibaba, only after the trial court framed charges against Saibaba. And he also said the sanction was given within 24 hours of time and no application of mind was given in this particular case of approving sanction, and that's why he said that the Bombay High Court was very much well within its jurisdiction to acquit all the accused in this particular case. So hearing both the side argument, considering the serious nature of the offence, according to the Supreme Court has suspended the Bombay High Court judgment, which means that Saibaba and others cannot come out of prison, though the Bombay High Court has acquitted all these accused. And also very importantly, advocate for Saibaba, Senior Advocate Basant, also told the court that whatever the condition if the court wants to impose, they can impose those conditions, including house arrest, but he should not be sent back to jail. But the Supreme Court has also rejected this request of house arrest, and Supreme Court has issued notice to all the 5 accused, and the matter will be again heard on December 8th.
So what is going to be argued on the 8th of December?
On 8th of December, the case will be argued on merits, whether the Bombay High Court was right in acquitting all the accused on this technical ground, that the sanction that was accorded under UAPA was whether it was bad in law, whether it was improper. Though the central government is saying that, though Maharashtra government is arguing that there was no irregularity in according this particular sanction against the accused, but the senior counsel appearing for Saibaba said that the sanction that was granted or accorded against Saibaba was given after the trial court framed the charge. After he was arrested in 2015, the trial court took cognizance of the charge, and after the trial court also framed the charge, and only after the charges were framed, a sanction was granted to Saibaba, against Saibaba in this case. And that's why they said that even though the sanction was granted, even in that particular case, there was no application of mind. The CFSL report and other reports were not considered properly, and within 24 hours, the sanction was given under UAPA, which is a very important aspect of prosecuting anyone under UAPA, the stringent UAPA, and that's where they said that they need to argue more on this particular case on merit. So Supreme Court agreeing to the request has sent notice to all the accused, and the matter will again be heard on December 8th, where the accused side or the respondent in this case can put forth their argument, saying that how the Bombay High Court was right in acquitting all these people on this ground, and Maharashtra government will be making further arguments on saying that this particular limited ground cannot hold water when it comes to acquitting people on such serious crimes.
Arvind, what was the argument made about Professor Saibaba's disability? What did his side say and what did the Supreme Court say?
When the Supreme Court gave this observation saying that they are going to suspend the Bombay High Court judgment, that's why senior advocate Basant, appearing for Saibaba, made this argument saying that the former Delhi University professor Saibaba is already 90% disabled. He is confined to his own wheelchair, and there has to be someone to take care of him. He has already spent almost over 7 years in jail, and that's why they said that whatever the conditions that the Supreme Court wants to impose on this matter, the Supreme Court should consider the fact that Saibaba is 90% disabled. He is confined to his wheelchair. That's why he should be sent to house arrest with any kind of condition that the court deems fit. But the Supreme Court refused this argument on the agreeing to the contention of Solicitor General Tushar Mehta, who appeared for Maharashtra government, saying that this is a very serious offence and no one should be put under house arrest also. And he said that in a current era, putting someone in house arrest will also give space for them to conspire again, and that's why he vehemently opposed any such request of house arrest, and Supreme Court also agreed with that. Now Saibaba can move bail application before the appropriate court seeking bail, because Supreme Court has suspended the Bombay High Court judgment. That means that Saibaba has to remain in jail.